Alright, so this case is Leebaert versus Harrington, and it was heard by the United States Court of Appeals, the Second Circuit, in the year 2003. The facts of the case involved a guy named Turk Leebaert and his son Corky Leebaert, and his son was in like a 7th grade health class, and he essentially wanted to withdraw his son from the health class, which was a required class by the district, so that because the class went against his fundamental beliefs. And so while it was still required, and the class was a health class that covered everything from like consumer health to physical, mental, and emotional health to youth suicide prevention to first aid, disease prevention, nutrition, human growth and development, and so it covered a whole array of things. The district did allow for parents to opt out their child for the 6 days during the AIDS education and the family life instruction, but the class was a 45-day class. They could opt out for 6 days, but they still required the full class. So it comes out later that his son had received an F, and he was hoping that they essentially would withdraw the F from his son's records and allow him to remove his child from the class and essentially choose what curriculum was important for his class. So then the court ultimately decided, moving on to the issues, the court ultimately decided that there were certain questions that had to be answered, one of which was whether Leebaert's asserted right, or the right to excuse his son from mandatory public school classes, was a fundamental right or not. With that question, they brought in a lot of rationale, which I'll get to in a second, but they ultimately concluded that it is not. So the final decision was that the parent does not have a fundamental right to mandate school curriculum. And part of their rationale with that was that if every parent had that right, it would be, to sum up, like virtually impossible for the schools to provide education for students when every student has their own mandated curriculum that they're following. And so, but beyond that, they pull in other cases. There's a case, an interestingly titled case, called Brown versus Hot, Sexy, and Safer Productions Incorporated, and in that case, they pull on that to show that essentially that it held that the parental challenge to a public school's AIDS awareness and sex education program was not rooted in a constitutionally protected right, which was Leebaert's argument that it was a constitutional right and that it required strict scrutiny versus how they put it as the lower rational basis constitutional standard of review. So they agreed that it met the rational basis, but he wanted a more strict scrutiny of it, and that's what came out of it. So in the end, they pull on a few other cases that we've read, including, towards the end, they pull on the Yoder case, which is the idea that it's his religion, and therefore he should not have to, due to his religion, he has these beliefs, and because of these beliefs, he shouldn't have to require his son to take this class. However, they found that in the Yoder case, it was a very specific to the Amish community, so therefore could not be used in this case because Leebaert's argument was that it was affecting himself and his son, not the entire well-being of the community as a whole, which was the case in Yoder. So and it wasn't going to threaten the way of life of the community by having his son go to the 39 required days of the health class, because he could still opt out his kid for the 6 days. And that is, and that's the case. That's what they decided on. So that was Leebaert versus Harrington.